situation without
No, I'm
knowing
not.
all of the facts.
Come on, counselor. Give me your legal opinion. This is a first year law student question.
I believe they would, more than likely. I think that would be a matter.
What would be the issues that would arise? I just want to understand how you think.
Sure.
That uneasy hesitation is more than just a personal slip. It marks the exact second a rehearsed script falls apart. To grasp the weight of this exchange, you must comprehend the mechanics of the Washington confirmation apparatus. Long before stepping into the Senate Judiciary Chamber, these candidates endure punishing practice rounds dubbed murder boards. Highly paid strategists and political consultants drill them on how to pivot, dodge, and stall. Their primary directive is to avoid hypotheticals at all costs, stick to safe talking points, and project an unbreakable facade of expertise. Senator John Kennedy just executed a maneuver that strikes fear into the hearts of Washington's legal elite, particularly these heavily coached judicial hopefuls. He isn't merely reviewing their resumes. He is actively dismantling their programming. He recognizes that a judge who cannot operate outside a memorized PR script will inevitably paralyze when confronting the messy, unprecedented dilemmas of human existence. In a mere fraction of his signature rapid-fire interrogation, Kennedy shattered their empty theoretical armor and measured their actual capacity for the bench. Do not skip a moment of this breakdown, because it perfectly illustrates how a seasoned lawmaker lays a psychological trap, cuts through the political spin, and forces nominees to grapple with the brutal reality of the law. Observe Kennedy's opening move. He refrains from tossing out convoluted legal jargon. Instead, he lulls candidate Coleman into a false sense of comfort with a casual question about Manhattan, only to abruptly hurl him into a lethal, real-world street crisis. Let's review this entire interaction.
Very busy, a lot of traffic. I don't know if you saw the news yesterday, but about 200 protesters in New York sat down in the middle of 3rd Avenue, completely blocked traffic. They were wearing T-shirts that said, "No war, no ice, free Palestine." Completely shut everything down for about an hour. Police had to come in. They arrested some of them. This is New York. Nothing will probably happen to them. But the point is it blocked traffic severely. Let's suppose a medical transportation service was trying to get a heart to a transplant patient in a hospital nearby. And obviously the traffic jam delayed him and the patient died. You with me?
Yes, Senator.
All right, does the patient's family have a cause of action against the protesters or the leader of the protest?
In any hypothetical, I would hesitate to completely prejudge the situation without knowing all of the facts.
Come on, counselor. Give me your legal opinion. This is a first year law student question.
I believe
I would hesitate. Without all the facts, on the surface, this mimics the disciplined restraint of a top-tier lawyer. However, through Kennedy's lens, it is an outright abdication of duty. This is the precise instant the illusion shatters. When Coleman seeks refuge in the excuse of needing all the facts, he is executing his training flawlessly. Yet Kennedy's sharp interruption, "Come on, counselor," acts as a harsh wake-up call. In the theoretical vacuum of a classroom, waiting for absolute certainty is acceptable. In the trenches of society and absolutely on the judicial bench, perfect clarity is an illusion. Judges are constantly required to render agonizing verdicts due to the haze of conflicting and incomplete evidence. Inside a Senate hearing, requesting more data acts as an impenetrable armor, but out in the world, judicial authority is tested exactly when data is fractured. As new cultural clashes erupt that legislation hasn't anticipated, a judge cannot merely strike the gavel and claim "I hesitate" by introducing the grim reality of a doomed heart transplant patient. Kennedy drags the law out of the textbook and into the realm of flesh and blood. Can a judge navigate the moral labyrinth to connect a street blockade to a lost life, or will they cower behind procedural ambiguity? By demanding an answer to a first-year law student puzzle, Kennedy delivers a fierce warning. The justice system does not require cautious consultants looking for an exit strategy. It demands intellects bold enough to step into the murky gray zones and distinguish direct from indirect causes amidst societal chaos. Coleman's stuttering exposed a critical vulnerability. He possesses the vocabulary of an attorney, yet completely lacks the commanding instinct of a true judge. However, Kennedy's absolute mastery is displayed during his cross-examination of Judge Powell concerning textualism, a legal philosophy that seems flawless in theory, where Powell asserts he only consults outside materials if the law's text is ambiguous. This doctrine is incredibly popular because it projects an aura of flawless objectivity. It allows judges to wash their hands of moral burdens by claiming, "I'm just an umpire," applying the exact words on the page. But Kennedy ruthlessly dismantled the hollow nature of this defense with a relentless volley of questions regarding the definition of ambiguity. He backed his opponent into a corner of sheer, logical absurdity.
Well, I mean, does it have to be 50% ambiguous, or 52%, or 51%?
Well, I'm not sure how to apply the 51. To me, ambiguity
That's what
is
I'm asking you, is how you apply it.
Well, ambiguity means that the words that are used are susceptible to two or more different definitions. So I don't know whether that's 50%.
Why do you go, I'm not suggesting you're wrong, but why do you go through that exercise? Why do you want to spend hours agonizing and debating how many lawyers can dance on the head of a pin to try to decide whether it's ambiguous? Why don't you just go look at the statute and also go to the secondary sources?
Well, that's what I do, Senator.
But you only go if it's ambiguous.
Well, because the plain words of the words, the plain meaning of the words in front of you are what guide you. And you apply the common understanding
I guess what
of the
I'm
words.
asking you is, Your Honor, why? Don't you want to look to the problem that the legislature was trying to solve?
The tension in the chamber spikes at the question, does it have to be 50% ambiguous or 51%? Unsurprisingly, Judge Powell is paralyzed because human language defies mathematical calculation. When Powell argues he only peers beyond the literal text when it hits ambiguity, Kennedy highlights the fatal flaw. Ambiguity isn't a metric you can measure. It is deeply subjective. Kennedy's counterattack serves as a profound philosophical reality check. He lays bare a harsh truth. Blind devotion to the literal text frequently operates as a disguise for cognitive laziness. Vocabulary has limits, while the suffering and evolution of a nation do not. Legislation written decades ago will inevitably feature blind spots when forced onto modern-day dilemmas. If a jurist refuses to examine the historical context or the core societal wound a law was designed to heal until a mystical threshold of ambiguity is met, they are not demonstrating judicial modesty. They are practicing intentional ignorance. The inquiry, "Why do you want to be a slave to the plain words?" makes it clear. An exceptional judge cannot be held hostage by a dictionary. They must possess the wisdom to grasp the spirit of the law. True equity is found in resolving the societal crisis, not in mechanically gluing words together. The concluding showdown with candidate Motiv delivers a profoundly different message regarding judicial power. Kennedy lays out a constitutional minefield. A McDonald's manager refuses to hire a Muslim woman wearing a burqa. Does corporate policy or religious liberty prevail? In the Capitol, an environment where massive egos and supreme confidence are the currency, encountering such a dilemma usually prompts a spiraling, evasive answer meant to appease everyone. Consider the crucible Motiv is placed in Washington. Is a theater where confessing ignorance is viewed as professional suicide. It's an ecosystem driven by arrogance where every participant acts as if they hold all the answers. The urge to pontificate and deliver a convoluted PR-friendly response must have been suffocating. Yet, watch how Motiv disarms the situation.
Mr. Motivi, I'm 17 and I go to work for McDonald's. I go to apply for a job and I'm wearing a burqa. And the McDonald's manager says, "I really want to hire you, but we don't allow religious symbols at my restaurant or at our restaurants." What does the law say about that?
The law prohibits the application of a religious test applied by the government, right, not by private employers. So I would say that's the basis of...
You sure about that?
Well, it depends on whether, I mean, there's other factors, right?
Let me just ask you, can McDonald's say, we have a policy against religious symbols and you can't wear a burqa? Who's going to win, McDonald's or the person wearing the burqa?
Honestly, Senator, I'm not sure who would win in that situation. I'd need to know more
I
facts.
appreciate your honor.
The second Mativ concedes, I'm not sure. The dynamics of the room shift entirely. This admission cuts right through the vanity that plagues the legal aristocracy. When an individual poised to receive lifetime authority has the courage to declare their own limitations, it is the furthest thing from weakness. It is the pinnacle of prudence. He recognizes that fabricating a hasty ruling simply to grandstand for the cameras could spawn a jurisprudential nightmare. A federal judge wields devastating authority. A misguided decision doesn't just generate news cycles. It shatters lives and alters the fabric of the country. Kennedy nods with genuine respect because he understands a vital principle. The most severe hazard to justice isn't a judge with a gap in legal trivia, but a judge possessing too much pride to admit they could be incorrect. Mativ's concession acts as a safeguard against the intoxication of power. Deep humility in the face of truth is the only mechanism that prevents the scales of justice from tipping into tyranny. Kennedy's ultimate genius doesn't reside in merely stumping the nominees. He transformed rigid legal concepts into a profound lecture on judicial integrity. Pay attention to the senator's definitive closing statement.
It's easy to play to the crowds, but when the going gets tough and you got to follow the law, and it's not going to be popular, that's what the rule of law is all about.
That's right.
The sheer gravity of this declaration fundamentally redefines the heavy isolation of the bench. The justice system was not built to pander to public opinion polls. When a jurist is confronted with a scenario where an outraged mob demands a specific, legally flawed outcome, that is the exact crucible where true valor is forged. Adhering to the statutes, when the public is cheering your name, is effortless, but upholding the rigorous letter of the law when you know it will render you a pariah, hunted and vilified by the press, that is the agonizing toll exacted by the rule of law. This serves not only as a warning to those taking the oath, but as a severe wake-up call to the citizens about the stakes involved. The individuals occupying these lifetime seats will dictate policy long after the microphones are turned off and the viral moments are forgotten. They will arbitrate your liberties, your livelihoods, and your most sacred convictions. Throughout 9 minutes of unyielding pressure, Senator John Kennedy delivered an undeniable mandate. The United States does not require algorithms that simply recite statutes, nor does it want polished politicians in robes. Kennedy's masterclass proves that a formidable legal education is entirely useless if it isn't anchored by an ironclad conscience. The ultimate benchmark of a jurist isn't their ability to quote past rulings, but their capacity to stare down a furious public and say, no. The federal bench demands razor-sharp intellects, unvarnished honesty regarding their own limitations, and supremely, the fortitude to champion the law even when the entire world stands against them.
A high-profile conservative lawyer just delivered a masterclass in double standards right in the middle of the U.S. Congress. She boldly declared weaponizing the government to destroy political opponents is a crime that kills the rule of law. Oh, wait, except when her boss Donald Trump does it. In that case, we suddenly have to calmly wait for the evidence, playing blind while a ton of bricks is flying straight at our face. This woman literally wrote the ethical rules, sat just feet away from those who enforce the law, yet is perfectly willing to hand out a get-out-of-jail-free card to her own side. Unfortunately for her, this slippery trick was dissected under the razor-sharp scalpel of a constitutional law professor, Representative Jamie Raskin. So let's see just how perfectly this trap was set, and what chilling truth is hiding behind this theatrical performance. Raskin didn't need to bring out the heavy artillery. He simply used the witnesses' Gina DeAndrea's own past speeches as bait.
By some of your political statements, one of the things you said at the end of last year was, if any political figure or party can direct federal law enforcement against its critics, we no longer live under the rule of law. Do you remember when you wrote that?
Yes, sir.
So do you reject Donald Trump's very public orders to the Department of Justice and the FBI to investigate and prosecute James Comey, Letitia James, Adam Schiff, a bunch of other colleagues, including Jason Crow?
I would say if there's reason and there's evidence to investigate those people, then he's absolutely right to call for it. If not, then he doesn't need.
Freeze frame. Did you catch that screeching U-turn? An ironclad principle. Anyone who uses the law to silence critics is a destroyer of the rule of law. But the exact moment the name Donald Trump is brought up, that supreme principle gets downgraded to a fragile IF. Suddenly, everything requires us to look at the reasons. To understand this blatant hypocrisy, you have to look at who signs your paychecks. Gina DeAndrea is the chief counsel from litigation at the America First Policy Institute, AFPI. Don't let the fancy name fool you. This isn't some harmless academic think tank. This is the shadow government of the MAGA movement, gathering the most rabid loyalists like Pam Bondi and Kash Patel. DeAndrea's job isn't to protect the Constitution. Her job is to drape a luxurious legal cover over her boss's personal political vendettas, legitimizing the hunting down of his enemies. Knowing this full well, Raskin proceeds to unleash his second psychological torture device.
Which you stated them. For example, you said that Maduro had refused to cede power. I think it was in the 2024 election, and you said that it's impossible to sustain a claim to lawful governance by a leader who holds office in defiance of his own electorate. Well, that really made me think about what happened in 2020, when Donald Trump claimed that he won the election, but the Congress found that he had not won the election. 60 federal and state courts rejected every claim of electoral fraud and corruption. But not only did he claim that he won it, he continues to claim that he won it. So I hope you would repudiate that.
Thank you for the question. I would say that he ceded power. He gave in. The President Biden was sworn in and was the president of the United States. So he did not illegally hold on to power in the manner that President Maduro, illegitimate dictator, did.
Oh, I see. In other words, because the coup didn't work and the violent insurrection didn't succeed in overturning the election, then you think it was all right what he did.
Respect.
Absolutely insane. The pinnacle defense argument of the Republican legal elite right now is because the coup failed, he is a respecter of democracy. Imagine carrying a gun to rob a bank, but unluckily failing to crack the safe. Then in court, your lawyer boldly declares, Your Honor, because my client botched the robbery, he is a model citizen. Unprecedented brazenness. Trump dragged the country through 60 baseless lawsuits, pressured election officials, and ultimately left a war zone at the Capitol. Yet in the eyes of this lawyer, a failed coup is whitewashed into a peaceful transfer of power. Let's pause and really digest the toxicity of that argument. If we accept DeAndrea's premise, we are essentially rewriting the legal code to state that intent and action no longer matter, only the final outcome. Attempted murder, just a misunderstanding if the bullet misses. Attempted election subversion, just a spirited debate if the vice president doesn't get hanged. This isn't just bad law. It is a meticulously crafted psychological operation designed to numb the American public. They want you to look at shattered glass, battered police officers, and a president who sat watching television for hours while his supporters hunted down lawmakers, and say, well, he eventually left, so what's the big deal? It is a calculated erasure of accountability, and it is being peddled not by fringe conspiracy theorists on the dark web, but by Ivy League-educated lawyers sitting under oath in the halls of Congress. And Raskin didn't miss the chance to deliver a knockout blow.
What's inciting a violent insurrection against your own government?
I'm not sure I understand what you mean.
Well, you're saying there's one thing about asking a question, for example, going to 60 different federal and state courts to try to get a ruling, but once you've lost all of those, you think it's legitimate within the rule of law and democracy to incite a violent insurrection, as Donald Trump was impeached for?
Sure, I appreciate the question. I don't have a clear answer for you on that.
Okay.
I don't have a clear answer. That dead silence is the exact moment AFPI's mask shattered into pieces on the Congress floor. And don't think this is just a theoretical squabble. The danger is that what she is being evasive about has already turned into a real-life nightmare. Let's look at this rap sheet. September 2025, on Truth Social, Trump calls out Attorney General Pam Bondi, AFPI's former boss, demanding James Comey and Letitia James be thrown in jail when genuine career prosecutors refuse due to a lack of evidence. Trump immediately purges them. The chosen replacement is Lindsay Halligan, a defense attorney without a single day of experience as a prosecutor, shoved into a position of power solely to serve the purpose of revenge. Think about the sheer audacity of that move. The Department of Justice is designed to be a shield for the American people, staffed by career professionals who spend decades learning how to navigate complex legal statutes objectively. Trump looked at that institution and decided it was nothing more than a hit squad waiting for a target. By installing his own personal defense attorney, someone whose entire professional existence has been dedicated to keeping him out of trouble into a prosecutor's chair, he didn't just bend the rules, he set the rule book on fire. This was a hostile takeover of the justice system. Halligan wasn't there to weigh evidence. She was there to execute a political hit job that career prosecutors had already flagged as legally radioactive and ethically bankrupt. It was a loyalty test, pure and simple. If you are willing to indict the boss's enemies without evidence, you get the job. If you demand facts, you get the boot. It wasn't until a federal judge slammed the gavel, threw out the entire indictment, and called this an unconstitutional abuse of power that this script was temporarily paused. DeAndrea literally wrote the book condemning this exact behavior, but she is ready to blindfold herself when the one strangling the law is the very person funding her organization. We are no longer just at red alert. The firewall maintaining the independence of the post-Watergate U.S. Justice Department has truly been leveled. World history always repeats a pattern. Every autocratic regime begins by turning the judiciary into the leader's dagger to stab political opponents in the back. Trump learned a costly lesson from his first term. Officials who keep their oath to the Constitution are stumbling blocks, and now, with the enabling of phony legal experts like Gina DeAndrea, he is wiping the slate clean of all remaining obstacles. We talk about what this means for you, the viewer, sitting at home. You might think, well, I'm not James Comey or Letitia James, so why should I care if the DOJ gets weaponized? You should care because once the machinery of the state is calibrated to crush political dissent, the definition of enemy expands exponentially. Today, it's a high-profile Democrat or a former FBI director. Tomorrow, it's a whistleblowing civil servant, a journalist who publishes an unfavorable article, an election worker who refuses to alter a vote tally, or a private citizen who protests at a town hall. When the law is no longer a set of universal standards, but rather a weapon wielded at the whim of the executive, the chill effect ripples through every layer of society. Organizations like AFPI are drafting the blueprints for a government where loyalty to one man supersedes loyalty to the Constitution. They are meticulously preparing the legal justifications for a purge that will make the first term look like a polite rehearsal. A justice system that solely serves the wrath of one individual is not the law. It is the death knell of democracy. The lesson Representative Jamie Raskin left us with is incredibly profound. Principles mean nothing if they dare not bind the person wielding the highest power. The GOP's flimsy curtain won't blind a world unless we voluntarily close our eyes. What do you guys think about the pathetic dead end this lawyer found herself in before Congress? Let me know down in the comments. If you found this content valuable, your like and subscribe will be a massive lever to help this video spread. See you next time for more razor-sharp political dissections.